Anywhere between 60 and 75% of my caseload as a lawyer is family law. And as a family law practitioner, I see a lot of domestic violence. And it has been my experience that when there are cases of domestic violence, you can see the abusive power structure, power dynamics play out in a court of law. And so it is not surprising to me that Blake Lively, hear me out, hear me the fuck out, it used her power and acted in a way that is abusive through the court system. And why am I saying that? Well, I'm going to read you the allegations in Jen Abel's amended complaint that was filed today, alleging that Blake Lively initiated sham proceedings in order to access the subpoena power through the court and to use that subpoena power without the ability of Jen Abel, who is Justin Baldoni's publicist, to use that subpoena power to obtain documents she wasn't entitled to without Jen Abel's ability to move to quash or object to those subpoena proceedings. That in itself is abusive. That is an abuse of power. That is using the court system for abuse. So in this amended complaint, Abel sets up the background where her and her previous employer, Stephanie Jones, were having issues. The Wayfarer parties, who is Justin Baldoni, and his production company were having issues with the publicist company, Stephanie Jones and Jonesworks, and there's a rift happening. And after that rift happens, Jen Abel hands over her phone to her prior employer. Now, she says, while the contents of Abel's communications do not support the existence of an untraceable smear campaign, which is what Lively alleges and has been clinging on for dear life to convince the public that there's this untraceable smear campaign going on against her, as opposed to just accepting the fact that the public might just not actually like how she behaves. Abel continues, they do show by the time of the film's premiere, Abel and others in the Wayfarer circle held Lively in deep disdain and vented acerbically amongst themselves. Those sentiments were the natural result of the Wayfarer party's firsthand knowledge of Lively's vicious behavior and malignant persona and the high-stress situation in which they found themselves. Please keep in mind that everybody who has worked with Blake Lively has not had particularly nice things to say or have chosen to say nothing at all. Except for the pants girls. And even then, that doesn't... Anyway. In turning over these materials to Lively, Jones knew full well how they would be used, with slicing, dicing, cherry-picking, messaging, and in some cases outright alteration, right? Because some of the texts were altered that Blake Lively used for her New York Times hit piece. You almost might call it a smear campaign, but oh, God forbid. The Lively parties exploited Abel's text messages to great effect. Joining forces with the New York Times, the Lively parties commissioned the hit. The Lively parties likely anticipated or were told directly the New York Times would not traffic in stolen communications, because that shit's super illegal, under these circumstances and needed the color of law. Jones and Jonesworks, for their part, wanted to insulate themselves from legal exposure to Wayfarer for breaches of confidentiality. I couldn't imagine why. Manat, who is Manat, I say it wrong every time, who is Blake Lively's attorney, initiated a sham legal proceeding in the New York State Court, Van Zandt Incorporated versus Doe's 1 through 10 inclusive. Now, I have mentioned on my page before, but if you're new here, filing a lawsuit against Doe's is normal when you don't know the identity of a party. However, you always know the identity of a party that you're contracting with, and you always fill in those does as you go along, or they drop off if there's no does to fill out. That didn't happen here. Let's go on. The sham lawsuit was nothing more than a transparent ploy to obtain subpoena power. The plaintiff, Van Zandt Incorporated, is a corporate entity affiliated with Lively and Reynolds and entirely unrelated to the film or Wayfarer parties. The lawsuit asserted 3 causes of action: breach of contract, breach of the implied covenant of good faith and fair dealing, which is a contract claim, and faithless servant against Doe defendants only, it does not explain how or why Van Zandt was unable to identify the proper defendants, which is especially notable in the context of a breach of contract action. It's like they came into my brain and wrote it down on paper with the emphasis. Anyway, instead, Van Zandt, who's really Lively and Reynolds, and Manette implausibly claim not to be privy to the identities of its own contractual counterparties or its own employees, contractors, agents, and representatives. The lawsuit is devoid of specific allegations against anyone, much less Abel, and relies exclusively on boilerplate legal jargon. Notably, Van Zandt never requested the assignment of judge, substituted the Doe defendants for named parties, like I just told you do, or served the complaint on any defendant. No service. Still were issued a subpoena. Because that's how it works. And the people who know that that's how it works are lawyers. This shit is unethical. There should be repercussions. The only docket entries are the complaint and a notice of dismissal filed on December 19th, 2024, the day before Lively filed her CRD complaint against the Wayfair parties. Curiouser and curiouser. The same day the lawsuit was filed, September 27, 2024, Jones warned a departing employee not to work for Abel because her business wouldn't be around much longer. It's almost like she knew. Once the lawsuit was filed, the Lively parties used it to issue a subpoena to Jonesworks for data stored on Abel's phone, including troves of private emails and text messages picked up via the application of highly generic search terms. The information turned over to Lively included communications that were plainly protected by the attorney-client privilege. Since there are no identifiable parties and no party had been served, the subpoenas were issued without notice, depriving Abel of any knowledge of the subpoena, much less the opportunity to object. Starting to sound abusive to you? Does to me. Abel is informed and believes, meaning that she doesn't have the evidence, but upon information and belief, she has a good faith belief to bring this allegation. The sham lawsuit was contrived by the Lively parties and Jones, acting in concert to facilitate and cover up Jones's release of the data extracted from Abel's phone and personal accounts under the guise of legal process. Under the guise of legal process, but not actually under legal process, without risking detention by interested parties such as Abel, who could have intervened to stop the flagrant abuse of process. I have been practicing law for too long for you to convince me that someone who acts like a fucking abuser and uses their power in ways that are abusive, uses their money, uses the law, and uses the courts in ways that are abusive, is a victim. Have the best day.